Okay, everyone, welcome. This is the Zoom webinar for House of Freedom Trust, Brilliance in Commerce, and the International Natural Law Trust monthly webinar featuring Tansen, myself, and Randall, our guest speaker, coming up in a few moments. So thank you for joining us, and we're going to have another very new, fresh stream of knowledge coming today on trust administration. And we will start with today being the date, July 17th, 2019, 7/17, a full moon last night, and a lot of high energy on the planet. So thank you for participating in this rising global wave of consciousness and the administration of worldly affairs using the natural approach. We have a question in the chat that he wants to know what that beautiful building is that you see on the screen. For those of you watching on video, it's a picture of a symbol. It's an archetype of sovereignty, of government, and of the light that empowers it. Because all of us at BIC, and those especially creating and using these trusts, come from a tradition of the recognition of the divine sovereignty within each one of us, regardless of religion, regardless of spiritual path, regardless of persuasion or of scientific understanding. There is a recognition in law and no less than 6 U.S. Supreme Court cases that Americans are sovereigns without subjects. And this principle has been recognized around the world as the divine government from the central sun that is manifest within the heart of each being. And so that Capitol building there is a symbol of that. It happens to be an ancient royal palace from India, but it could really be from anywhere. There are similar architectural styles in most countries. So Brilliance in Commerce is a project of La Vérité, which means the truth in French. House of Freedom International Natural Law Trust is our topic today. We also have the Liberty Debt Elimination System and affiliations with a lot of other offers and outsources and assistances of all kinds. So those who haven't already should explore the website. We are a signatory to the Worldwide Charter for Fair International Commerce. There's our certificate. You can see it on the screen and also on the website. Today being Wednesday, July 17th, 2019, we're going to take a break in August. And those who are on vacation will enjoy, hopefully, a nice summer. And we will take a break from these webinars during August and reconvene in September. So our next trust webinar will be September 18th, 2019. Now that means trust webinar open to the public and given by Randall Hillner. There will, however, be the usual continuing trust study group series in August, given by Dominique Hackett for clients of the Natural Law Trust. And you would be watching the newsletters for that. For those who have not already seen the archives of past videos, go to www.brilliance-videos.com, and that will be your YouTube Brilliance in Commerce channel for all of these videos. And those who have not already subscribed to the newsletter, please do so at house-of-freedom-trust.com and click newsletter sign up. Our USA phone number is 360-200-7521. My name is Tansen Fairmont. I'm the founder and speaker on various radio shows, board of advisors of Monaco Management Group, author Sovereignty Consciousness, and the forthcoming Cosmic Renaissance. We have a question in chat. Is there sound? Could anyone please write into the chat and tell me if you are hearing? We got a yes. We got another yes. Okay, good. All right, very good. Thank you very kindly, everyone. Okay, good. So, Susan, I don't know what you may be watching the chat. Okay, very good. International Natural Law Trust, for those of you who are experienced with this, forgive a quick review. For those who are new, the reason it's called international is because it's not jurisdiction specific. And we deliberately wrote it that way in order to make it available to every country. Some countries don't understand, some banks don't understand, but generally, contract law goes everywhere. It's basically contract law, the right honored in just about every tradition, every jurisdiction, the right of two individuals to go into contract with each other, or three individuals, four individuals, without interference from the government, as long as they're not harming anyone or violating anyone's rights. So that's the basis on which these trusts are written. It's very simple. It's a universal right. It is respected in the Uniform Commercial Code, which is the highest law that is actually practiced by governments and banks around the world. We can say it's a common law trust, but there are so many inferior common law trusts out there that have gotten people in trouble, that are poorly written, and we wanted to distinguish our common law trust and use the word natural law to reflect a greater degree of perfection, a greater degree of attunement to universal law. Randall Hillner is our illustrious speaker. He's the head of our trust department at Brilliance in Commerce, founder of House of Freedom Trusts, White Light Unlimited, trustee of One People's Public Trust, and the creator of these natural law trusts. So, Randall, I'm going to bring you on. We're going to go ahead and unmute you, bring your video on, and we're going to go to the topic for today, issues in trust administration. And Randall, you are on. Aloha.
Well, aloha to you and aloha to everybody else, and welcome to another beautiful day in Kauai. And I hope you're having the same thing wherever you are. You're not being flooded or not being parched. And thank you for joining. And thank you, Tanzan, for all the good work that you've been doing for all of us all along, bringing about the ability to create these beautiful trusts that we have, a contract, like you said, between 2 or 3 people or 4 or a number of people. And we're going to talk about basically issues in trust administration. And we're going to talk a lot about the role of the trustee and what they need to do to be the top of the line. So you're going to get some information here. If you're a client, you know you haven't diligently read about the trustee roles, et cetera, then that would be some homework to do. There's a tremendous amount of information involved in the trust manual that comes along with the trust. And of course, we have, you are a client, then you have Dominique Hackett and her trustee lessons once a month, like I'm doing here with Tanzan. And she has picked up quite a bit of information. And every time she has a question, she just texts me or writes me an email, said, what do we do here? How do we handle this, etc. So it's quite, she's very ambitious and really wants to serve all of the clients. Now, in addition to being offering the information about trusteeship, she is also offering her service as a nominee grantor. So some of you might be in a place where you want to have more anonymity. You might not have people that around you that supports the vision that you have. So you can use Dominique for 2 things. One is her service will be a nominee grantor service. When we were working in the Caribbean, whenever you got an international company, it was quite often a nominee grantor, nominee creator for that service. She also is giving an excellent trustee service. So if you feel a lot of people they want to be a trustee, but they want somebody that can be a trustee that knows more than they do. So she's offering her trustee service as well, and she's quite good at it. So that's a good source to look for. And if you need any help with that, then either Tanzan or myself or the office can give you an email to connect up with her. And that's, of course, if you're a client. If you're not a client quite yet, then either reach out to the BIC office or reach out to me. I think Tanzan, on the webpage, Tanzan lists my email, but not quite sure. Anyway, in spite of all of that, we're going to go right into today's topic, and that's basically how a trustee will be selected or how he's going to perform. So I think there's a next slide, and we'll get going. So here we are, we're initiating and safeguarding and defending the trust. So the first thing is a trustee it's a choice to be a trustee. Trustee must agree with you. If you have somebody in mind or you have good friends and you want them to be a trustee, they would accept that position. And then once they do, they are obligated to serve you very well as either the beneficiary or to be the co-trustee with them. And that's the purpose of the trustee. The trustee's primary goal is to make sure that the intent of the trust, the content of the trust, is held intact to carry out the desire of the settlor. Now, or whoever is putting the assets into the trust. Sometimes the settlor is putting in the assets into the trust. Sometimes the trustee or somebody else may assign or gift the trust with some assets, and that's perfectly acceptable. So then the trustees are going to carry out the intent. And in the trust document, if you have one already, if you don't, then you will get the gist of this. Is the way we write it is so that the whole idea, the whole concept of this 30 to 40 page document is so that there's an asset that's going to be put into trust, signed to the trust, either gifted to the trust or assigned to the trust. And for that, the role of the trustee then is to administer those assets and make sure that they are kept safe and or promoted or enhanced. Basically, the trustee's job is to also to figure out how to administer the assets so that they grow in equity, and the equity will eventually go to the beneficiaries, and that can be later down the line, or typically the trustees will pay out on a monthly basis to the needs of the beneficiaries. So the trustee's job is to make sure that the assets are held in high regard and they administer that with reasonable care and prudence. Now, a trustee doesn't have to be an expert in trust law. I'm always available for consulting. Dominique is really catching up, and going to be as competent as anybody else. And between the two of us, we can get you the information so that when we help administer the trust for you and or the trustees, then it's taken care of. Now, a typical trustee doesn't have to be an expert like myself or Dominique, but they just need to have reasonable care and prudence on how they take care of these assets. can be, depending on the assignment of the assets, it can be put into a very conservative fund, or however the person that's putting the assets into the trust, how much they might want to be taking care of those, or they may be more aggressive and they want to say, okay, Mr. Trustee, I want you to be as aggressive as you can with this asset, and I want this to grow as fast as possible. So there's lots of in between there. Let's say we put in $100, and we're young and we're growing and our family's growing, and so we're going to keep some of it in a more stable, secure funding process, but we're going to take another fair share and we're going to put into aggressive funds. And depending on the trustees, or you, if you're one of the trustees, you may have an expertise in the area of managing money, or taking money to the next level. And so you might find an aggressive place to park that asset, and therefore it would grow faster. So you always have some growing, some is always stable, and some is always available to be paid out to the beneficiaries. So that's the nexus of being a trustee and having a good trustee take care of your assets. And again, one of the things that I really like to do is whenever one of our clients needs some help in administering or getting some insight into how to administer these funds, then that's what my job is. Tanzan obviously is taking more care of other things in this process, but you can always come to me. And now, if Dominique's involved with your trust at all, you can also go to her, and if she can't answer it, then she'll come to me, and between the two of us, we'll make sure that you and your trustees know exactly how to resolve the issues. And it's really not rocket scientist. I mean, if I'm doing this, then anybody with reasonable care and prudence can do this as well. So, now, one of the things that's really important after administering all of this trust assets is the trustee must be really careful to never commingle the funds within the trust. So let's say the trustee is a trustee on two trusts, and it's really necessary for him, if he's going to do these two trusts and administer both of them, that he needs to keep the funds separate. And so that's not only between two trusts, but he must not commingle the trust funds with his own personal funds. And that will breach the trust. The honor of the trust will come crumbling down quickly if you start to use trust assets to pay for your personal needs as a trustee. Doesn't mean you can't cut a check to yourself as trustee for the work that you do, but it's really important that you don't use the trust asset to buy personal stuff for yourself. That's one of the most reasonable and things that you really need to consider. So that's the first slide, and we should move on to the next one if it's ready. The prudent investment rule. That basically, there's a lot of leeway. It's just the standard of care. In other words, what would you do with your own funds if you were prudent and caring about the assets that you held, whether it's in your pocket or whether it's in the trust asset pocket, you would use your best judgment to make sure that the whatever is invested in is safe and it's always there to enhance the asset base for the beneficiaries. Now, beneficiaries sometimes start out yourself, maybe you and your partner, or maybe you have children. So rather than one beneficiary, there may be 4 or 5 or even 10, because I have some clients that are grandparents and they have children, and those children already have grandchildren. So they want to parcel that beneficial interest out to make sure that they all are taken care of. And it can be given out, it's a ratio basis, a percentage basis. So maybe your children are the most important right now. So you're going to have most of that beneficial interest go to the children. And then there's some trickle-down effect that can go to the grandchildren later on. So in other words, once the grandchildren are 21 or of legal age, then they can be paid directly. In the meantime, if you have it go to your grandchildren and they're minors, then you would pay the guardians that beneficial interest, and then they can take care to make sure that the children and grandchildren are taken care of. Now, one of the rules is that if one of those beneficiaries becomes sick or needs an immediate funding source, perhaps they want to go to school, they've got a chance to go to college, and so it's okay to pay that beneficiary a bit more than you would give to the other beneficiaries, because right now it's important that that person be taken care of. So that can be done. In other words, it doesn't always stay to this, everybody has to get equal share. It can all be divided up as you go along. And again, the trustee must act like she's investing for herself. Again, it's like you, diligent as you hope to be, make sure that you're investing as if it's for yourself and your own enhancement, but you know that it's going to the beneficiaries. And that's why professional trustee service is really provident for us, actually, to come across somebody to do this. Dominique in particular, she's going to be the trustee service. I have too much going. I'm taking care of the clients and making sure their trusts are up to standards, and it's a big role to be a trustee. And I think we're also looking at other people to really step in and offer a full carte blanche process where you have nominee grantors, you have professional trustees service. And this does not mean at all that it's going to make it a statutory trust. This is still a very natural law process where you have selected another sane, prudent person to help you with this care, but it relieves you a lot of thinking about having to take care of the assets. Somebody else can do it, and somebody else can make sure that reporting is done, they record everything, it's all kept in a form that's readable, and like any bookkeeping service. If you have a big asset base, you have a bookkeeper, and so that bookkeeping service would also be used for making sure that the care of the trust and the beneficiaries is there as well. Next slide, please. Okay, now the trustee really only has the powers that are defined in the trust document. So if you have one of our documents, you'll see it's very clear that under trustee powers, there's trustee duties and there's trustee powers. And those powers are not unlimited. They're defined within the document, but they are as broad as you can imagine. But the ability to, for the trustees to make sure that this whole assignment of assets is well taken care of, well thought of, and is prudently invested. Now, the trustee, because of that situation, because of that interest he has in a trust, is that he's under a fiduciary responsibility to really make sure that those assets are protected and enhanced and in the best interest of the beneficiary. So the trustee is always thinking about, okay, how do I make sure that these assets are safe? How do I make sure that the beneficiaries are paid on a regular basis if that's the way the trust has been set up? How do I make sure that if somebody needs, one of the trust or beneficiaries needs a particular an additional payout to take care of an emergency situation, that is done. If you perchance, and more clients are doing this, the client as trustee will be a co-trustee with our professional service or with a friend that may be a co-trustee. And more than likely, you're going to have the checkbook and the bank card. It's your responsibility as co-trustee, even though these are your assets. When you put your assets into the trust for the benefit of somebody else, you have given those assets to the trust and they're no longer yours. You must remember that. And that's why we talk about commingling and the need to not commingle those trust assets with your own. So that's really important. But once you get it, you get it. You don't use the trust to buy yourself toothpaste. Just pay yourself a check and then cash it as a trustee fee and make sure the beneficiaries are taken care of. And record keeping is done in an orderly process. You can hire a bookkeeper or you can do it yourself. With electronic banking today, use of a card or a check, everything is recorded and you have it online all the time. So when it comes to making sure that there needs to be a monthly report to the beneficiaries or to the other trustee, that would come about. Every time, if you are a trustee, every time there's a decision and an action that's taken, that's recorded as a minute and put into the binder for the trust document, and make sure the other trustee, typically in any kind of major decision, you're going to speak to the other trustee, the co-trustee, and you're going to make sure that he's agreeable to that decision, and then he would sign. Then both of you are under that fiduciary responsibility to make sure that that action actually takes place. Okay, next slide. Oops. Okay, I'm going to have to wrong button, sorry. Okay. Okay, so this is again getting into the third party. So oftentimes you're going to have here is a trustee. You're going to go into um, a need for somebody else to take care of the money. Let's say you go to an investment house. You have a third of your assets in the trust, and you want to allow that fiduciary or that fiduciary responsibility to go to a third party. Now, again, you're going to, just like the trust is a contract between two people or three people, when you go to an investment firm, you're going to sign, or in the bank no less, you're going to sign a bank statement you're going to have a contract with the investment house, and they are going to take that responsibility to make sure that what you give them for the trust is going to be well taken care of. They have a reputation to perform, and you have a reputation to protect, to make sure that that investment house also takes responsibility for it so that you can be responsible overall. So in other words, if you give it to a third party, you need to be on a regular basis checking in with that investment house and saying, what's it going? Usually, usually you have an on now, or you have an online, or at least in the old days, you had a monthly statement that came from that investment house, and it said you got this much, or we lost a little here, but we got it back. And then so that's what you would do. You would make sure that the bookkeeping is in order. The financial statements are in order, and then you can make sure that that asset base grows and grows for somebody else's benefit. Now, I can't see this. Okay, that's better. So now the trustees may delegate to a co-trustee or third party for any duty beyond their expertise. That's what I was just talking about. It's hidden behind this whole face up here. So we have the delegation that you can give to a third party. You can do it yourself, or you can give it to somebody else. You can enter in multiple contracts with a number of third-party people, and you're always looking to find and delegate to sorry you want to find somebody with expertise, period. Just like you've come to Natural Law Trust to get one of the best trusts that you can get on in present time. There's lots of trust documents out there, and you can buy them anywhere from $200 on up. However, I've had trust clients come to me and they said, I bought this trust for $250, and they gave me a trust document, but there weren't any instructions, and there was nobody there to consult with later, or that person had all of a sudden disappeared. So you need to be wary of something like that, and that's why with Tanzan and myself, we're always there on some level. If Tanzan can't, the questions come into Tanzan or the BIC office, Tanzan is either sending an email, or his Peter in his office is sending me an email and saying, how can we deal with this? And I get together and I look at one of my favorite books. Can everybody see that? Hope. It's in the bibliography, and it's my go-to book, and there's always something in there where I can find out what your question might be. And if it takes me a day or two to find it, I'll do it, but it will work. And it's behind the green screen now, but I have another series. I have a whole row of books that will give me more information if it's ever needed. But typically I've got the experience to give you pretty much what you need to have. Okay, next slide. Loyalty. Aha. Now, duty of loyalty. And this is, again, I think I've already kind of stepped into this, but it's proprietary that the trustee uses best, standard care and skill to make sure that those assets are protected and taken care of. And loyal to the trust and loyal to the beneficiaries. Obligation to administer the interest for the beneficiaries. And that goes along with keeping records, don't commingle, keep really good bookkeeping, and be loyal to the trust. Because if you're not, and something goes awry, then you can be held in a breach of trust, contempt for breach of trust. You've broached or broken the loyalty to the trust, and you're responsible for that. That's loyalty. Loyalty to your partner, to your interest of the people that you're taking care of. Okay, next slide. Questions already, good. So who's got questions?
Okay, everybody. If you're calling in by phone, press *9 if you want to raise your hand. And those who are on the, computer, you can click raise hand, or you can type into chat. Thank you, Randall. This is fascinating. And although a few principles we've heard before, there's always something new in every webinar, a new angle, a new, fresh introduction of principles. I was just curious while we're waiting for questions to come in, that book that you showed, Law of Trusts, what is the source of that law?
It's a history of time, and it's all based on the early English common law. It's basically honor your contract and don't hurt anybody. And out of that English, British common law, hundreds of years ago, came these aspects of what it is to make sure that this contract is kept intact. And it's always being tested. I have, in the end of each chapter, there's probably the chapter itself might be 10 pages, and I've got 4 pages of court decisions that say this is why this is happening on this particular aspect of it. So it's all substantiated by past court cases. It's all mostly common law. Obviously, statutory law comes into hand, and it's okay, but the law is the same, whether it's a common law, natural law trust, or whether it's a statutory trust. And the only difference is we don't register our trust documents with anybody. We don't need to be an attorney. All we need to do is know the law that substantiates the particular aspect of what we're looking for within that trust document. I've gone over this for 40 years with 2 or 3 incredible mentors, and it's still the same thing. There's I don't have it, but there's I had 27 volumes of Scott on Trust, and now it costs about 10 grand to get that volume. And he was a leading gentleman in the 1920s and 1930s that really defined the American version, the law of trust, the law of contracts. And it didn't matter. He was in very incredible genius mind, and he wrote it to fit both ways. It didn't matter whether it's a statutory or non-statutory document. The fact is that there were certain basic laws and parameters that the contract is based on. And can call it all kinds of things, but it's like you said, Townsend, in the beginning, you honor your contract and you don't hurt anybody. And if you can do that, then you're fine. And it doesn't mean that the trust can't sue somebody. It doesn't mean that the trust can't be sued. If it steps on somebody's toes and causes damage, then it can be sued. And so you have to be willing to defend it. And one of the jobs of the trustee is to defend the trust. So you have to look for that as well. That's why it's good to have, if you're not too savvy on that, that you might want to have a professional trustee service. Doesn't mean you have to have it. It's just helps. And doesn't mean you can't go to a lawyer if the trust causes damage or some third party doesn't honor the contract that you made with him. Then you need to defend the trust and go to court and fight for that position.
Very good. Thank you. Well, questions are starting to pour in here, but just quickly before we get to those, one more thing about this. I think it would be helpful for people to understand the difference between the law under which the trust is written and the law under which transactions can be disputed. In other words, the trust doesn't derive its permission to exist from any body of law, except just
Correct.
the universal contract law. In other words,
Correct.
it can't be invalidated. However, individual transactions or actions of the trust officers could be brought under a specific jurisdiction or statute for some specific action. And it doesn't address the trust itself. It just addressed that particular action or transaction, right?
Absolutely. And that you typically, whenever you're dealing with a contract, you're in a court of equity. In other words, you're trying to straighten out the equitable solution and how the equitable resolution can happen within that dispute, whether it's actually a physical liability that happens or whether it's a contractual liability that happens. It doesn't dispute the essence of the trust and what it is. It just addresses what the action was that created the upset.
Right. Perfect. Okay. Marion asked, if this is a private trust, who is going to be the gatekeeper to ensure the trustee is not paying for personal things? Could it be written into the trust that trustee is to be provided for?
Yes, the trustee, it's totally equitable for the trust to pay the trustee for his service, whether it's a friend or whether it's a professional service. The trustee fees are very equitable, and it's written off as an expense of the trust, and can be for a professional service or for your friend or for yourself. In other words, you may be the one that's putting the assets in, and you may decide to be one of the trustees, and once you put that asset into the trust, you're under a fiduciary responsibility that you now look at that fund as an asset of the trust, and you must act accordingly. You must act as a trustee. And that's why, with all the apps you have on the computer today, your spreadsheet, your ability to write minutes, you just have a simple format, and every time there's something that happens, it's written down. Every time that there is a monthly statement, it can be put on a spreadsheet, so that when you keep records like that and they're clean, then you really it's going to be easy to defend, and it's going to be hard for anybody to come in and say this is not fair, because it's right there.
And you could have it, couldn't you have it written into the trust that the part of the compensation to the trustee would be, in addition to a direct payment to the trustee, could be payments to certain of the trustee's major expenses, like a mortgage?
That's kind of, no, I wouldn't do that. I would, if the trustee is worthy of his fee, then he should have enough to cover his mortgage. Doesn't, now, if you're going to cover a mortgage for somebody, then I would highly suggest that the trust has an interest in that, the equity of that mortgage. In other words, I would not suggest at all that you use a trust to pay for a mortgage unless the trust itself has equity in that house.
Okay.
So
that makes
again,
sense.
You're trying to slide something in that I wouldn't want to have you defend. Have the trust buy the house or buy into the equity, then the mortgage can be paid for by the trust. But if it doesn't, then I want you to pay the trustee a fee enough to cover his mortgage. But that means the trustee should be doing a lot of work.
Okay.
Now, if he's doing a lot of work and putting in really good investments, and the trust is making enough money to cover that mortgage, then that's fine.
All right. Paulette asks, do the beneficiaries have any voice in the decision making? Can the trust continue for generations? Sounds like two questions.
The beneficiaries cannot dictate what they want from the trustees. In fact, there's a paragraph in the trust document that says exactly that if a beneficiary ever comes after the trustees or the trust and says, I demand more, that the trustees can, by unanimous vote, say, you know what, we're taking you off as a beneficiary and we're going to spread it out to the rest of the beneficiaries. So that usually keeps that particular beneficiary from pursuing anything like that. Now, we also have in that document is what's called a spendthrift clause, so that that beneficiary can't alienate, like say he gets 10%, 10 units of beneficial interest as a beneficiary, he can't use that 10% and go out and alienate that and put that unit of interest into a contract. The trustees can say, if you're going to do that, we're cutting this off. So you can't alienate your interest, and you can't put it in jeopardy. Otherwise, the trustees can just quickly take it back and prorate it to the other beneficiaries as well. So that usually keeps the beneficiaries in line. The beneficiaries can ask for a reporting of what the trustees have done over the past period of time. Usually it's it depends on the activity of how much is in the trust to begin with, how much activity there is. If there's minimal activity, then once a year. If there's significant activity, it could be once a month. You could trustees would give a report to the beneficiaries, and they would have a check and a spreadsheet on what happened and what they did and why they deserve all of that and how much they can look forward to in the next period of time.
All right. And Paulette's second question is addressing what you've talked about before, but perhaps it still needs to be made clear for everyone, and that's about the duration. She says, can the trust continue for generations?
Yes. It's the initial trust document is 21 years plus lives in being. Okay, so I think I explained this earlier, but if you, let's say you have children now, you created this trust, you've appointed your trustees, you have children. So it'd be 21 years from the time you sign, 21 years plus after the passing of those children. Now, in that time, or towards the end of that time, the trustees easily just say, we're going to renew this trust to go on for another 21 years, and then it just keeps on being renewed. Or if the assets have been run down, or there's a splitting, let's say the assets have been so well enhanced that out of those 4 children, you might want to create 4 new trusts, and each one of those children would receive a new trust document, and then it would be 21 years plus their children. And so it would go on and on and on and on, like we talked about before, the Rockefellers and the Kennedys, and it just keeps on going. And one of the reasons it keeps on going is because when you have every asset in trust, it never dies, it never goes through probate. Whereas if you have it in your own pocket and when you pass, then it has to go through probate if it's over a certain amount. I think it's a couple $100,000. It may have gone up now, but typically if you have a major estate and you don't have it in trust, it's going to go to probate, and then the lawyers in probate will sit on it for 2, 3, 4, 5 years, and so the family gets kind of squeezed out of the picture. And by having it in trust, then that would never end, and there's never probate.
Well, thank you. All right, cool. And then Mata asked, just wondering if there is a disagreement between the 2 trustees as to asset management or other issues. How is it resolved? Is there a mechanism for a trustee to be removed?
Sure, you can always go to mediation. And then one of the other things that we have is we have a protector's agreement. And so their protector can be appointed by the grantor. And they would say, well, okay, you got to resolve this, or we're going to let one or the other of you go, and we'll appoint 2 new trustees if we have to. So come to some resolution, mediation. Usually with mediation, that's enough to clear the air. And usually if during that mediation one of the trustees will say, I don't want to do this anymore, and then another trustee is appointed and goes from there. Now, if you have 3 trustees, it's a majority opinion, so 2 out of 3. But 2 trustees have to be unanimous. And in all of this time, I've never had a call saying, hey, my trustee won't let me do this, so what are we going to do? This basically never happened in my history. It doesn't mean that it hasn't happened, but and that's what the law books are all about, is they have to go to court, or they go to arbitration, and the resolution is handed down by a court of equity, and that's what the law then stipulates. In this situation, this is going to take place. This is the precedent that will allow the one trustee to override the second trustee. Is that clear, I hope?
Yeah, I'm just imagining that kind of situation. And like you say, fortunately, we don't know of any instance where that has happened. I think we attract really nice people who don't seem to have much conflict.
Well,
yeah.
I have had very few, I have a term for it, but I won't say it on air. Some trustees come to me and they're a little upset, and I said, okay, just take a breath, and what is it that you feel that you need or you're not getting, you can't do? And usually within a conversation, it's pretty much taken care of.
Yeah.
But yes, you're choosing your trustee because he's either a friend, somebody that you trust. And until we had Dominique come along and offer her trustee service, I've always had people say, well, I want my friend. I have a friend. He's willing to be trustee. And I may have to talk with the trustee, the other person, and say, okay, what's your question? What's your hesitation that you would not want to do this? And they say, well, this and this and this. And I say, well, okay, well, either don't do it or this is how to handle the situation so that you could do that easily. And if there's a dispute, you can email or call me anytime, especially once they're a client. I don't have any problem.
All right. Charles asks, many of us will be using our trust to fund various projects and or charities to support the good of humanity. How are those organizations handled like beneficiaries and units of beneficial interest? We only have 100 such units. We may have more than 100 organizations we give to.
Okay, so that's reasonable. And what I suggest is a lot of our clients are now coming and I say, well, why don't you make just call it, we're going to make one of the beneficiaries that your humanitarian projects. And so you don't have to list the particular projects. You just say, I want a percentage, I want so much percentage to go to a project that I want to support, whether it's 1 or 20. I have 21 to 25 projects that I want to support that are all been, they have management in place. They know exactly what they want to do. They have a budget in place. And so all I have to do is cut a check depending on, how I want to do it. And probably what I'll do is I take that 80% that I've dedicated to humanitarian projects and I'll just say, okay, when the exchange happens and this new thing comes about, then you just cut a check. As many projects as you want. Got a check, fund it. You can fund it as in the beginning, you can say, here's your startup capital. When you've proved to me that your project is going well, give you another one. When we were building houses in California, you took a third, you only got a third. And then in that time of the frame standing up, you got another third. And when you got your finish, you got it all closed in, then you get the other third minus 10% holdback. And then after the inspection, then you got the rest. So can easily be done. And the trust by law can give up to 100% of its potential profit to anybody it wants to. Doesn't have to be a recognized charity, doesn't have to be a 501, doesn't have to be a 508, it can be a ministry, or it can be a 501, but it also can just be a project that you want. And most of the humanitarian projects are all set up and ready to go, and they're not there to necessarily make a profit other than to keep on perpetuating this particular project, which will go on for a long time, hopefully.
So to clarify, another way of saying what you're saying is that you could have categories out of the 100 units. Let's say 100 represents 100%, right? You could say, for example, 20% goes to a category called charitable organizations, and then those organizations could be listed within that category or not. They could be added later. Another category could be family beneficiaries. Another category could be investments. Is that right?
Well, you don't have to go that to that extent in the beginning. What I have is I have a number of clients that have 80% are going to go to the humanitarian projects. 20% is going to go to the client and her family. So she might have 2 or 3 children, whatever it is. So let's say 20%. Then she takes that 20% and divides it out as she wants. She can give more to one child and less to another. But the humanitarian projects, you just, especially when this exchange happens, there are going to be wealth managers there, and you're going to say, okay, I have 25 projects, and I want this 80%, whatever that whole totality would be, I want it to go equally to all of these 25 projects. And then you can always add more later. or let's say a couple of projects don't make it and there's still money left over earmarked to go to them, then it can go to another project, go back to a project that might be doing really well. There's
Okay.
some incredible humanitarian projects out there, and whether some of my clients they're actually brainstorming to create their own projects, and I'm saying, well, there's lots of projects out there that are really looking to be funded. So ask around instead of trying to create a management team and a budget and anything like that. Just go find one. Like I have here in Kauai, we've been trying to get a bike lane around the island built for 20 years, and the corrupt local government ate up all the money, and so it's like 20% built. And that's one project that I have. I have the budget account, I have the management in place, and percentage of this thing will go to make that bike lane. So it doesn't matter what it is. I have clients that have these particular ideas that they want to do. They want to create these humanitarian things that support the planet. Doesn't matter what it is.
Speaking of fundraising, let me just mention for everyone's benefit that if anyone is looking to raise millions of dollars for a good cause, and if you haven't already, see on our website at the top, click on fundraising, and you'll see an ingenious idea there for how to empower a no loss, no risk guarantee for anyone who you might approach for funding. Now, Marion asks, is the fee considered income? This means the fee from the trust to pay, I guess, trustees compensation for their services. And Randall, I might just comment that that depends upon, Marion, your status, whether you have documented yourself as a non-taxpayer and whether
Right.
you're protected in that way. If not, then yeah, it might be designated as income. But I would look at, if I were you, the section of our website under legal help, look at revocation of election. So on the website, it says legal help. There's a menu there. And you scroll down to revocation of election and read that, and you will see a 100% successful system authorized by Congress that has been making people exempt. And so then that question is no longer relevant. You want to add anything, Randall?
No, I know the gentleman, and I know we've been doing good work, and I've been on that realm for almost as long as I've been doing the trust. And in other words, I've been working in that realm of helping people get out of the system as long as I've been using the trust work and writing trust contracts for everybody. So it's very appropriate if you're at all involved. One is you get the trust set up and then get your assets assigned to them. And then the two is you look at, do you want to file a 1040 for the rest of your life, or do you want to stop? Can be
All right.
done.
Next question is, after the trust is created, say 3 years ago, can the indenture be modified or added to?
Yes, we can make amendments, and I'm willing to help with that. But I would, again, you'd have to go in what do you want to do, and is it appropriate? Does it take away from the intent, or does it add to the intent? So you don't really change the structure of the original. You add an amendment, just like the Constitution has amendments added when it's appropriate to change something about it. So you don't change the trust document, but you do add amendments to it.
Do you provide a template for that?
I know it'd be an individual basis, but it would Well, we know that there's already two amendments to the trust document already. And so as we find more things that we need to include within the document, then I would probably have an amendment. But I don't have a template per se. But if you're looking for ideas and you are a client, then just pop me an email and we'll we'll work something out.
All right. Marion asks,
You
who
know,
is, go ahead.
that's really simple. It's like talk with the trustees, and we think that we would like to change it so that it reads like this, so that we can enhance the structure of the trust. I mean, it's always an individual case. It depends on what you want to do, and I can help you with that.
All right. Marion asks, who is the gatekeeper that ensures the trustee is not spending money frivolously? And this was addressed before, but perhaps she needs a
Correct.
repeat.
Well, he's gonna, whoever's involved, for one thing, he's probably not going to be the sole trustee. I don't really like sole trustees, but the co-trustee would be a gatekeeper. And if there's a breach of trust, if the trustee isn't doing his job, then that trustee that's outside and saying, hey, look, Mr. Trustee, you're not, this is not appropriate, and I'm going to bring it to mediation if you don't stop, or you don't I want that checkbook, and you don't have the right to spend it unless we have a unanimous decision together.
All right. And then she says, who dictates the 21 years? There is no authority but us, right? Isn't that the point of a natural law trust, that we are not subject to someone else's authority?
It's not about authority. It's just been written in law for the last 300 or 400 years that this keeps the structure. In other words, if it's a charity, it can go on forever. It goes on into perpetuity. A trust is different, and it's not a charity, and it's for the benefit of others, but it can be for the benefit of yourself. And therefore, just through 300 and 400 and 500 years of trust law and cases before the court, they said, this is how a trust is run. It's run for a period of time plus lives and being. And it's not like a dictation. It actually defines the fact that this trust is going to last for so long, and then you have to get together and renew it. And therefore, you don't need any government influence in it, but you don't. It's just the way that trust law has come down. That's all I can say.
Makes sense. Well, have you ever heard of a trust being invalidated because it went beyond the 21 or the normal time? I mean, has that ever been challenged?
No, because it's 21 years plus lives and being. So if the client is, say, 50 years old, it's going to be his life plus 21 years. So that's a fairly long time. And in that time period, there's going to be changes in trustees, there's going to be changes in the beneficiaries. Some beneficiaries will pass on, and there'll be other beneficiaries, trustees may be passing on, etc. So I've never had an issue with that.
Have you ever read about or heard of a case where anyone challenged a trust because it was not renewed, but it kept on going anyway?
No, I've never come across anything like that. Every time I look at it, that in the books, it's the judge relies on the fact that it's 21 years, and if the trustees are doing their job, they're not going to let that happen.
It's not going to come to a court anyway, right?
No, the trustees are going to make sure that if there's a time frame and it needs to be renewed, that they are going to do that, and they just write a minute and says, as of this date, we are now renewing this trust document for another 21 years plus lives and being right now.
I guess, like you're saying, it's sort of the concept means it's not so much an issue of coercion or, you know, dictation
No.
of any body of law, but just more like common sense because the
Well,
purpose
it
of a
is.
trust is to hold assets on behalf of a beneficiary. And if you were going to say, well, I'm holding these assets on behalf of these beneficiaries forever and ever and ever and ever, that doesn't make any sense because it means they'd have to
No.
wait a million years before they get their distribution or something.
No, and the way our trust document is written is that it's discretionary, but at some point you want to be paying the beneficiaries. The whole intent of this trust is to enhance the assets and to be able to pay the beneficiaries.
Right.
Common sense. It's natural law. It's like, okay, our job as trustee is to take care of the beneficiaries. I mean, it's kind of like a charity in one sense, but it's more defined by it's defined by trust law rather than charitable religious law. That's all. That's all I can say. It's just the history of law through time has generated this purposeful definition. It's not like it's come from a statutory judge and said, "Oh, we are going to define this." No, it's just the evolution of law, especially in early English law. They began to define how law would work in a justifiable way. In other words, it was different. The common law of Britain was one of the freeing concepts that allowed people to break away and be and this is what goes back to the Crusades. The Crusaders would go off to fight the war, and they left their property in the hands of a trustee, and that means if they didn't come back, then the beneficiaries would get the benefit of the estate, and there would not be any probate. So it would just keep on going on and going on, and it just went from generation to generation, and the trustees would change, and again they would renew it and make sure that it's up to date.
Okay. Gita asked, can you alter the trust as time goes by, add or take away donations, etc.? And Gita, I don't know if you heard Randall's answer earlier. He was saying you can't alter the basic indenture, but you can add amendments. You want to add anything to that, Randall?
Oh, that's perfectly fine, and you can add or subtract, but again, you want to stay within the initial purpose of the intent of the trust, which is to take care of the beneficiaries. That's the whole idea.
Right.
And you may be one of those beneficiaries, and so you want to make sure that, I mean, if you're doing this, if you're working with us, you're not the kind of person that wants to be greedy and wants to keep it in your own pocket. You want to take care of your family or friends or projects or, your community, whatever you want to do. And that's why now I'm having so many clients saying, I want a major portion of this funds in this trust to be going to humanitarian projects.
And Steve asked, what if you reside in another country?
This is um, this is an issue I have come up against recently, and I'm working on resolution for this. But there's a gentleman that's down in, I won't say where it is, but it's outside of the U.S. And they keep saying that the bank won't recognize that particular form. Now, I've a form of contract. So in other words, they don't know how to deal with a trust. Now, to some extent, it's not written in Spanish, so it's probably hard for the banker, if he doesn't understand English, to really grasp the concept. I've had people in France had a little rough time, but we got through it. People in Quebec, even though they've had no problem with the whole thing happening. So I've only had one or two clients say that the like, see, Spanish rule is, is is not a common law. They don't rule under common law. And either do the French. They have Napoleonic law. So like when I had a book written on trust law in France, and whole interpretation was really different. It took me forever to get through that book because they had been trained in English, they had gone to English law school, and then they were back in France trying to create these trust documents or something similar to that in French. And they did resolve the situation, but it took a fair bit of time. And the way the trust document was written was different than we would write it here in the US or the Western common law country.
What I don't understand is why don't all countries just understand the UCC and contract law? That's pretty universal.
Because they want you to write a contract in their country based on their understanding of how trusts work. The UCC is different. The UCC is universal contract law, and it should all be the same, but it's not. A lot of people don't operate under the UCC. They don't, unless they're very well versed in the Uniform Commercial Code, they don't get it. And that's why the three of us went to Morocco and to Switzerland, was to serve banks with this paperwork that said, hey, above all, the UCC stands first. And if you are the secured party, there's nothing you can get from me until you've proved up that you have a right to step in to my space. It's like, the law needs to have a subpoena to come inside your house. And if they don't have a warrant, they're not allowed by law to come inside your house. So you say, I'm sorry, Mr. Officer, you can't come in here. I had an IRS gentleman, and I literally threw him off my deck. Oh, well, not literally, but he did not like it. He had never had anybody stand up to him and say, where's your warrant? Where's your subpoena? You have a bogus IRS paper that's not signed by a living human being. It's a computer-generated paper. It's not signed in wet ink. And where's your badge? Well, we don't need no stinking badges. But anyway, it's an interpretation of everybody's social standing, and everything's going to be different. I don't know what to add to that, but unless you're in some twisted country, which many of them are, you shouldn't have a problem.
Yeah, and just to add to that, we've had lots and lots and lots of clients, maybe hundreds in foreign countries, who've had no problem. But sometimes things arise because, like you say, misunderstandings.
Sure.
Yeah.
I mean, in England, they don't need a tax number to open up a bank account. She walked into the bank and showed her ID, and they said, fine, no problem. Opened it right up.
Sure, we'll take your money.
Sure. Well,
you want to add a story at the end or any humor, because it looks like we're out of questions and we could end early.
It's a humorous day. That's all I can say. Every time. What was our little humorous fiasco this morning at noon o'clock, trying to scramble this program together?
Yeah, to see the slides. Oh, well, I just wanted to raise something. You remember Charles Miller. We are back in touch. The guy's mellowed out, Randall, over the years. For those of you who don't know him, look on our website at Legal Help and then scroll down to Liberty Classes by Charles Miller. We just put up the page. As
Great.
10 years ago, he was not so harmonious, but today he's mellowed out a lot and he's learned a lot. And he brought up an idea. He was saying Airbnb, and this can relate to anybody with real estate, especially if you rent out the real estate. He said in Hawaii, they're having a problem with the Hawaiian government rules and regulations on rentals. And he
Yes,
said,
we
well,
went through
if
that.
they can get the owners of the Airbnbs to put it into a natural law trust, and then instead of renting the property, we give the would-be renter a unit of beneficial interest that specifies that it's only for a week or two or however long they're going to stay. They're not renting it and they don't fall under rental properties. In fact, what they're doing is, in effect, buying a timeshare.
Yep,
It's just a one-time temporary timeshare in the form of beneficial interest.
great idea.
So this could be
Yes,
a genius solution, everyone, for anyone who has income real estate.
boy, that's sweet. Yeah, in Hawaii, they won't let you trade Bitcoin. They won't let Coinbase in, so you can't trade cryptocurrencies here in Hawaii. For some reason, the only state that doesn't allow that. It's weird.
Um,
So, yeah, there's always around it.
we have, sorry, I didn't see this. Charles says, is Mata's question above answered? It was, how does one determine what is a reasonable fee to pay a trustee?
That's strictly between the trustees and the settler when you're setting it up. I mean, I charge $120 an hour for my consulting, and a trustee, depending on the amount of work, could charge, like I said, in the early days, I think we talked about this, we would go with the settlers, and they would go to a restaurant and have a trustee meeting for maybe half an hour or an hour, and then the client would buy us dinner for the evening, and that was fine. If I'm sitting at my computer putting a template together to create an amendment for your trust, then I'm going to charge accordingly. The trustee, if he's doing a lot of work and signing a lot of paperwork or contracts, then I think it's whatever you feel is fair. And the trustee has to say, we're fine, we're friends, I'll do this, I'll do a certain amount of work for this much, but after that, throw me a six pack or whatever, take me to dinner, or buy me a greasy hamburger at McDonald's or something.
One idea came from Mark too for high net worth trusts, that a percentage of the asset in the trust would be assigned to the trustee, especially like you say, if it's doing a lot of work, if he's doing buying and selling and investing and management, wealth management type services.
Well, I would just pay him as a wealth manager. I wouldn't give him equity in the assets necessarily, but I would definitely pay him any wealth management. You call up an investment house and say, how much do you charge for, per hour to take care of my investments? And they either give you a flat fee or they say, we take a percent of the profit.
Yeah, he wasn't talking about equity. He was just talking about like a 1% or 2% of the amount in
Yeah,
the trust as
sure,
the fee.
sure, sure. Could do that. It's all between the trustees and the people involved, mostly the trustees and the grantor.
And I will say I do not provide trustee services, but I did for one party, and that party paid me $1,000 a year, and all I did was about once a month I would send a bank wire, maybe sometimes twice a month. So it was
Nice.
a reasonable fee because there was some work involved in sending the wire, putting the paperwork together, and all that.
Sure. Yeah, you deserve your fee, period. A man deserves to be compensated for his work, whether you're a cowboy or a lawyer. It's up to you.
Mata says, so I assume trustees do not need the same fees. No, it depending on the value of the trust and the amount of work being done yeah.
Yeah, absolutely. And I think Dominique she has a flat fee for her nominee grantor service, one-time fee, that's it. And for her trustee fees, it's between you and her, and she charges accordingly. If she spends uh, she probably tells you this is what I get per hour, and if she works for 15 minutes, she bills you for that 15 minutes. That's fairly equitable. It's like any really good consulting firm would charge you on a hourly basis and bill you for the time spent.
Same with law firms. Yep.
Yeah, for sure.
Okay.
But me, tons, and I tend to be very liberal with my time because my whole basis of offering this service is that I like to build my relationship with people, and and that's worth it to me, even though I give away maybe more than I should sometimes. But if it gets to a point where I'm always on the phone with somebody, I said, look, this is okay. From now on, we've got to structure a fee service here so that I can feel like I'm getting compensated for the work that I do.
Mata, you're saying, no, I mean the two trustees of the same trust, can they be each paid differently? And yes, that's what we're saying. It depends on the amount of work they do and the value they give to the trust.
Sure, there may be basically an active trustee who's doing most of the work, and a second trustee is just there to occasionally say, well, maybe look at it this way, and I would hesitate to say yes to that. And so they would be paid less accordingly. But it's strictly up to how you want to put it together and how you value your time. If you're really close friends or family with this a person that's setting up the trust, it might be a little bit more easy to negotiate whatever you got.
Would you say that a lot of the trusts, maybe a majority, have inactive second trustees?
Yeah, especially like if like a client will have a nominee grantor, they'll have a friend be the nominee grantor, and they'll be one of the trustees, and they'll have a non-related co-trustee friend, and their family would be the beneficiaries. And so they would do most of the work, and the second co-trustee he's got to be unanimous in giving the first trustee, the one who's doing all the work, the unanimous decision to say, fine, I think what you're doing is great. I agree. I'll sign the paperwork. It's not a problem. And getting into that is, there's no worries about having a trustee in two different cities or even in two different countries. It can all be done by Skype or by scan or by emails. Illegal notaries or witnessing can go fly across countries anymore, so it's not a problem.
Any stories you want to share with us before we close?
Oh man, the surf has been so fun. The water is really warm. The flowers are blooming. It's beautiful. And that, the joke's on me.
Well, when is the whole world going into the golden age?
Yesterday, I think the full moon was last night, wasn't it? I am the walrus. Boo boo, ba-joo.
Yeah, and you've got beautiful views of dolphins and whales there.
Yeah, this is a nice story. I was talking with Victoria and her beautiful clan of young ladies down in Aussie the other week, and she said, "What does it look like there?" We didn't have the green screen up, so she said, "What does it look like?" So I just took my camera, the computer, and I opened the window and flashed it out, and she said, "Wow, it's so green." He said, "It's so cold and damp and brown down here." I guess they're down in New South Wales. So she was very enamored with the greenery that exists in Kauai. And I would highly recommend any of you that if you have a chance to get to Kauai, then come and enjoy.
So I'm going to call it a business write-off, right? It's a business trip.
Absolutely. Coming for consulting.
Consulting, right.
Yeah,
Consult Randall and then consult the Dolphins too.
absolutely. I'll take you right to where they pop up every morning. I've been down there almost every morning at 9 o'clock. I go about a quarter mile off the shore in my surfboard, and the dolphins, the spinner dolphins, we call them, they're up jumping out of the water and playing and chasing those little fishies. And how can you miss?
Mm-hmm. Well, thank you, everyone. It was a wonderful time. It's an hour and a half. That's a reasonable time. It's between an hour and 2 hours, so perfect timing. And if you want, we can wrap up unless there's anything
Yeah,
else.
I'm ready. And I'm glad we got it straight from, what was her name? Teresa?
Well, there was
Woman at
Marion and
Zoom. No, Zoom. The woman for
oh
Zoom.
yeah. Mm-hmm.
I was I was really worried that we weren't going to get that fixed before we went on, and it did.
Yeah.
So I'm ready to wrap it up and sit out and look at the sun again, and I'll be ready in September. We'll go at it again. And please, all of you who are clients, um, please email me any questions. And if you're not a client, then get it together and get yourself a good natural law trust.
So we're taking a break in August for those who didn't catch the beginning of our time today. And so our next webinar will be in September, and that's going to be the 18th. Please enjoy a wonderful time in August. And in the meantime, of course, we're available by email and support tickets and phone. And if you're already a client, then you have access to Randall. And thank you for all of your thank yous. We're seeing a lot of those coming in the chat. So have a wonderful summer, and may all of you continue to enjoy the rising tide of global consciousness, because that's what we're participating in and contributing to. And there may be a day when asset protection is not so necessary, but just distribution and organization, which these trusts will continue to be useful for, even when there's a world that is no longer beset with thieves. It's just an efficient estate planning tool.
Yes, absolutely. No matter how the world evolves, the trust for your assets is really important to think about.
All right. And right at the end here, I wanted to share this with you. A mind once stretched by a new idea never goes back to its original dimensions.
Very good.
Aloha and mahalo.
Yes, to all of you, aloha. Come and see me in Kauai. Come on, I'm lonely here. I want some company. Aloha, everyone.
Okay, thanks. Take care.